for those of you who are FOIA regulars, this is going to include some very remedial stuff, but for those of you either who haven't used FOIA before, or for maybe it's been a while since you've used it, just some very basic practice pointers, an overview of the statute, and specifically the points that I think will be helpful leading into the discussion of this particular lawsuit. So assuming that everybody can see the slides up, again, my name is Max Mishkin. I'm an associate at Ballard Spahr in the DC office, and my colleagues Chuck Tobin and Crystal Tupcha and I represent the coalition of media plaintiffs in the FOIA lawsuit to find out who has received funds under we've been using PPP as a shorthand. It's actually several programs, which I'll get into briefly, but who has been getting access to PPP funds and in what amount. So today, 3 parts, again, FOIA overview, talk about the lawsuit, and then open it up for some questions. So what do you need to know about FOIA to understand where we're coming from in this lawsuit? FOIA is a federal statute, and it provides a statutory right of access to federal agency records. So right off the bat, a couple of points. You cannot use FOIA to obtain records from Congress or the courts. For courts, you have a constitutional and common law right of access to records that is the subject of a whole other presentation. And you can't make an agency create records. This comes up more often than you might think. You can ask for records or information, but you can't force them to be created. And the general presumption that FOIA creates is a presumption of access and then sets up a series of exemptions that rebut that presumption. So the general rule with FOIA is if you ask a federal agency for records on a given subject, they have to release them to you unless those records fall into one of 9, I was going to say specific categories, but they're in fact incredibly broad categories. And sort of the usual suspects of what we see in FOIA denials are the ones listed here. Exemption 1, national security. Exemption 3 is where basically they can point to some other statute on the books and say, well, that says this information is secret, so we can't give it to you under FOIA. Exemption 4 is for trade secrets. I've bolded it here because it is, we don't yet know what the reason is that the SBA is withholding some of this information, but we suspect that Exemption 4 is going to come up. Exemption 5, interagency. You see this a lot. It's an extremely common exemption, and it covers all manner of sins. It's basically deliberative communications among agency figures. And it has been recently amended to create a sunset period, I think after 25 years. But still, it's one of the most broad exemptions you see and keeps you, frankly, from obtaining records that are probably of the most news value. Exemption 6, personal privacy. Personal privacy, again, bolded because we think it's probably something or it might be something the SBA asserts in the PPP context. And the interesting thing about Exemption 6 is that it creates a balancing test between the public interest in the records and the alleged risk of harm for an invasion of privacy of the records being released. And then Exemption 7, law enforcement, which is actually a series of sub-exemptions. So you don't normally hear reference to Exemption 7. You'll hear 7A, an active investigation, or 7C, law enforcement records that would pose an invasion of privacy. And so, like I said, each of these exemptions is actually quite expansive, and agencies, will be creative in how they're cited. The process, again, very basic overview. You send in a FOIA request to the agency. In this diagram, which I pulled from a GAO report, this presumes only one of 2 outcomes. Either they deny the records or they don't respond. The interesting thing about this case is what happens if they respond, but it's not really a response. But either way, as you can see, if there's no response, you can go right to court. If they've denied it, you have to go through an administrative appeal process. And once you've exhausted your administrative appeal, then you can go to court. So I think that does it for FOIA basics, and that turns us to this particular FOIA lawsuit. So, you've been talking more broadly about, CARES Act and funding. As you know, the CARES Act created sort of several pots of money that businesses affected by COVID could get access to. The centerpiece of the CARES Act is the Paycheck Protection Program, the PPP, but there's also the EIDL, Emergency Impact Disaster Loans, and then these two other, which we have not really addressed too much in the lawsuit, but the PPP and the EIDL, we basically treat as sort of as one unit in this FOIA lawsuit. But the interesting thing about the PPP, which is sort of important to flag up front, and you can see here, is that the way the SBA describes it is this loan program provides loan forgiveness for retaining employees by temporarily expanding the traditional SBA 7A loan program. So there exists this prior SBA loan program known as a 7A loan in which small businesses can receive, sort of federally guaranteed loans. Now that's important because if you were to go on the SBA website, you would be able to get all of this information about every 7A loan, I think back to the 90s. These are all the field categories that you could get, and it's a lot. It's information about the borrowers, information about the lender, information about the loan itself, information about sort of the impact of the loan. Jobs supported, for instance, is a particularly important one if you are looking at if you want to know how these small business loans are promoting and supporting small business jobs. But importantly, you would get the actual dollar amount of a 7A loan, and you would get the terms of repayments, interest rate and payments and things like that. So knowing that all this information is available about Section 7A loans, and knowing that the PPP is an expansion of Section 7A, you might think, oh, and one more thing, I got ahead of myself. You might also have looked at the PPP borrower application and seen this little information on it that says to people who are applying for PPP loans, your information is going to be public under FOIA, at least, consistent with how we've treated 7A loans. So you know all that about the PPP, or at least you think you know that. And so you, like many journalists, might decide to file a FOIA request with the SBA, and you might ask for records of all the Paycheck Protection Program loans from date certain to date certain, and you want all the information that's provided for 7A loans. Seems like a reasonable request. This information has been treated as public for decades, right? You would expect, sure, here you go, here's the database newly updated. Instead, here's what many journalists received: a form letter that basically says, we're working on it. Here is some, quote, statistical data, which is to say broad aggregate data. And when we get, when we stop being so busy, we'll turn around to getting you loan specific information. So as we discussed earlier, the agency has responded, but what is this? Is this it's not telling you what they're going to give you when they're going to give it to you. And so we are, of the opinion that this is not in any sense meaningfully a response under FOIA. And the support for that, interestingly enough, is a decision from then Judge Kavanaugh from the DC Circuit in 2013, which basically said, and this is an important thing for all FOIA practitioners to keep in mind, is that an agency's duty to respond to FOIA actually has a little meat on the bones. They need to tell you what documents they're going to give you within the statutory deadline of 20 working days, what documents they're going to give you, what documents they're not going to give you, and why, and inform you that you can appeal that determination. They don't actually have to give you the records within 20 days, but they have to make that, quote, determination. And if they fail to do that, it's as if the agency didn't respond at all, and you can go directly to court. And so that is what we did on behalf of a coalition of press organizations that have submitted, overlapping and slightly different, but in broad strokes, all FOIA requests for PPP and/or EIDL information. Some of these organizations decided to treat that non-response letter as if it were a denial and filed administrative appeals. But all in all, this coalition of organizations, which sort of expanded, there was an original group of 5, and then we filed an amended complaint and added the rest. And so where we are right now is we have filed an amended complaint and the SBA has filed an answer which basically admits or denies what we have alleged. More importantly is that the SBA has announced that it is, producing some information voluntarily. It has produced that information. And as you probably know, they've given no loan-specific really information for loans below $150,000, and then for loans above $150,000, they've provided not dollar amounts but dollar bands. So you know that Bob's Sporting Goods received a loan of $1 to $2 million, but you don't know the specific dollar amount. In our case, Judge Boasberg has ordered that by today, the SBA is supposed to give us any records that we've asked for that they don't consider exempt. And I have one eye on my email because that could happen anytime today, but we don't know what they're going to give us. We don't know whether they're going to say all the stuff we've released last week is what we consider non-exempt. But we will know more this week about where this lawsuit is headed, specifically based on what the SBA is going to withhold from us and force us to litigate to get. So that takes me to questions. I'm happy to take them now. And of course, the usual caveat for a lawyer answering questions online is please don't ask questions that would divulge privileged information on your part. If you have a question for me, sort of in my actual capacity as a lawyer, feel free to shoot me an email, and we can discuss offline. So for the good of the group and for your own good, try to keep questions a little general if you can.
Okay, Max, I got a question or a comment. If you could stop sharing your screen I want to show.
Yep.
Okay, so he was talking about the 7A program and the data that are available on that.
Mm-hmm.
I just want to give you a heads up. I think you are seeing this Excel spreadsheet right here from the SBA website, and we'll provide a link for this. They have the SBA 7A data from 1990 till today available. It's in 3 chunks: the 90s, the 2000s, and the 2010s. Each one of those databases is roughly, I think one of them 700,000, one of them 600,000, one of them's 400,000 records. So they're too big to combine into one big Excel spreadsheet. Most Excel is usually limited to a million records. If you have SQL Server or some other database program, you could combine them in one there. If you want to analyze it just in Excel, you need to, you can just look at the last 10 years or the aughts or the 90s. And this is, you can just see, this is all the information that they have, which is, quite a bit of information, including the company, the lender, the NAICS code, the interest rate, whether it's paid back, congressional district, all this kind of stuff. And so we'll provide links for you so you can kind of compare what has been made available over the last 30 years to what they're doing right now.
All right, Karen from WNYC asks, do you know any reason why the cutoff was $150,000? So I can tell you what the public statements that Secretary Mnuchin has made, which is that their theory is that below $150,000, well, I guess I should say, the reason that they are withholding information in theory is this notion that if you know how much money an organization has obtained from its PPP loan, and you know some other information about the organization, you can deduce individual payroll numbers. At least that's the theory, and that those individual payroll numbers are the types of information that businesses tend to keep closely held. That obviously relies on a number of assumptions about what you might already know about your, for instance, competitors, and why you would know that, but not the information that you would be able to deduce. But more importantly, why that is a risk below 150,000 and not above 150,000 is a great question, and we are eager to hear from the SBA, hopefully today, why it is that they are drawing the line at 150K, which is real money. And more importantly, the SBA has been touting publicly that the loans above 150K represent something like 85% of the total dollars that have been dispersed. but the loans under 150K are approximately 85% of the total loans. So, there's, depending on what you're looking for, there's a huge amount of information that's being withheld by not disclosing, borrower details below 150K.
Max, those numbers again. The big loans represent 85% of the money, and the small loans represent 75% of the recipients. Is that right?
I think it's something. I mean, it's something close to the 80-20 rule in both directions. I forget if it's 85 or 75, and I have not crunched the numbers myself. But that's give or take. That's basically the distribution. The bulk of the money is above, the bulk of the loans are below.
What about jobs saved? Like, do you know how that breaks down?
I don't.
Okay.
I also know that the data that has been released is somewhat incomplete. So a lot of the information that the SBA has put out already is missing information that they, so far as we know, aren't claiming is private. It's just that the table is dirty. They didn't groom the spreadsheet well enough. So it's hard to know, even beyond the dollar amount, sort of what is what is being withheld purposefully and what is being withheld sort of just by agency, spreadsheet entry practices. Oh, got a couple of questions.
If you can see those chats, you can just field those.
Yeah, sure.
Sophie
Okay.
Katikov is from the Raleigh News and Observer. Don Lee is from the LA Times. Johnny Edwards is from the Atlanta Journal. Jake Hyden. Oh, lots of questions. Well, just start.
This is great. Yeah. Okay. I'll start at the top. Okay. From Sophie, I understand there will be a bit more info collected on the loan forgiveness application. Business owners can voluntarily report their rates, for example. Do you expect SBA to release this data? So it's an interesting question, and I don't know in short, because this is the loan forgiveness application is in part what makes this such a giveaway of federal dollars, right? Is these are quote loans for now, but these are loans that will essentially be converted into subsidies. And you would think that the fact that this is essentially a giveaway of money increases the need for public oversight and transparency of the information that goes along with it. So I think our position would be that this information should be made public. It helps provide the oversight, and in particular, the sort of voluntary reporting of race. I've seen some initial reports, sort of the city level, individual reporting saying, oh, well, look at Charlotte, North Carolina, see the breakdown of which businesses have received loans and which are minority owned. There are, at least at this early stage, there are some interesting questions to be asked about whether PPP money is being distributed equitably. And so I am hopeful that that information will come out. I guess, technically speaking, it is not at issue in the complaint as filed, but we'll see what happens. From Don, what are you expecting to get this week? And for news organizations that aren't part of the lawsuit, would they have access at the same time? Another excellent question. So I'll start with the second point, which is, if the SBA wants to, they probably could just post data online and tell us, hey, we've responded, and make it available to the world at the same time as they make it available to us. I don't think, that is not in my general practice of FOIA litigation, how agencies tend to do it. They tend to, send a DVD with data to the requesters. But it is possible, and in certain circumstances, if an agency is feeling cheeky, they will post the data even beforehand in an attempt to sort of scoop the scoop. And so we don't know what we could get a DVD in the mail, we could get a share file link, or we could get directed to a link on a website that the entire world can access. And then what are we expecting to get this week is also a good question. I mean, it could be that they just say what we released last week is what we consider the non-exempt information, and everything else, you're going to have to sue us over. I find that a little unlikely, if only because we've also requested information about the EIDL program, and I don't think they've released anything about that, and I don't think there's really been discussion about whether the agency is going to consider confidential. So I'm hoping that we will at least get EIDL information. I'm very hopeful, that is to say, in my most optimistic, we would get a lot more PPP information once they realize that their arguments for withholding them don't hold water. But you know, in FOIA litigation, I have learned not to let myself get too optimistic about what an agency will do without a court ordering them to do it. Okay, so in your opinion, this is from J. Red Edwards. In your opinion, what was behind the limited release of PPP data? What is SBA's strategy? You know, it's hard for me to speculate about what they're thinking, other than you know, a lot of oxygen was breathed up in reporting, you know, so and so got a PPP loan, and maybe they are thinking that, you know, all the initial coverage about who got loans, you know, will sate the appetite of journalists who will move on to the next story, and then if and when they are forced to release the numbers, you know, there will be less coverage if, for instance, the numbers bear out that there are, you know, racial or gender or other inequities in the disbursement of loans. That is, you know, that's pure speculation on my part on what their thinking might be. I know that there's also been quite a bit of pressure on them from congressional oversight to release information. So you know, it impossible to put myself in the head of the agency, but I think it is probably something to do with getting ahead of the story, and something to do with you know, they couldn't just stonewall forever. They had to, you know, release something, and this is what they decided to release. So next question, is the government addressing errors and missing info in the data release thus far? I haven't seen anything. I admit I have not been, you know, sort of checking day to day to see if they've, you know, released updated versions. So I don't know. I haven't seen any reporting about it. So I hope so. You know, I think it is important to get this right, especially because it is going to be the subject of considerable reporting, and you know, this is information that is sort of uniquely within the SBA's purview to provide to you and get right. So hopefully. From Michelle, for the info they released, can we get the actual application forms they filled out? I don't know. I don't know. You know, in my research for this, I don't think I've come across a question of whether, for instance, you could, in the ordinary course, get 7A application forms. I think if you happen to know that you can get those, then I think, you know, that's probably the, you know, a good argument. But you know, sort of going to FOIA first principles, it's a record that is in the hands of an agency, unless they have, well, I will say this, the application might actually go to the bank, and then the bank sort of inputs the information into a form and then transmits that to the SBA, in which case it's not clear whether the application form itself ever truly became a, quote, agency record. But let's, you know, indulge the hypothetical that some people, you know, filled out these forms and mailed them to, you know, the SBA administrator. I think the FOIA would impose on the SBA an obligation to release those records, you know, redacting whatever information is exempt. But it's not something that we have, you know, we are interested in the information, not so much the forms. And I do think that sort of, you know, while FOIA requesters don't necessarily have to explain themselves and why they're interested in what they're interested in, depending on what exemption is cited at you, you might have to explain the public interest in seeing the forms per se and not just the data. So it's, you know, if it's something you're interested in, I would encourage you to sort of, you know, brainstorm about what the public interest is in the forms. From Emily or Emil, what is the best way for us individual reporters to ensure we are receiving all PPP information that SBA supplies to the plaintiffs? If we've also filed FOIAs similar to the ones exhibited, should we expect to get the data in a timely manner too? So what's the best way for individual reporters to ensure we're getting PPP information from the plaintiffs? Well, I guess what I can tell you is that once information is released to the plaintiffs, as again, sort of FOIA first principles, there's a principle called release to one is release to all. So once information comes out, anybody else who asks for it should be able to get it. And there exists a sort of new category of information, that is to say, frequently requested records are supposed to be proactively posted online. And so, you know, I think that if enough people have requested these, and a lot of people have, at some point the agency is obliged to just post it online, and then everybody gets it. Until then, and it's not clear, like I said, whether they're going to produce information to us in a DVD by mail or what have you. I think that there's no way to guarantee that you're going to get the information first. And so, I think the members of this coalition will either get it first or will get it at the same time as everybody else. And then, sort of the follow-on reporting. And that's, that is, with my advocate hat on, like there's you've got to incentivize journalists to file FOIA lawsuits. And if they, if they don't have any expectation that they're going to be able to, report the data that they received first, that incentive might go down a little bit. And then, sort of the FOIA doesn't operate as effectively as a tool for releasing information to the public. And I know that's a subject of dispute about like what the principles of FOIA say, but it wouldn't surprise me if the plaintiffs get this information first. And then, if you filed your own FOIA request, depending on what the agency has responded to you, I think that again, they're likely to, if there's not another lawsuit out there, they're likely to like I said, put it online at some point, but it's not clear when. From Chance, at this point, do we know of any entities that were denied PPP loans? Will we ever be able to get the information if SBA claims it hasn't maintained that data? I don't offhand know of any organization that was denied a PPP loan. I know that right now, at least for my sort of cursory search through the data that's been released, they're not providing information on loans that have been, quote, canceled, which includes some of the higher profile, borrowings by well-resourced companies that then got a blowback when they report, especially the publicly traded ones that had to disclose it to the SEC. That, thanks to investigative reporting, became public, and some of those companies facing the backlash gave the money back. My, again, sort of cursory read is that the SBA does not consider those loans to be, quote, repaid, but rather to be, quote, canceled, and they don't feel the need to disclose them. So, I don't know sort of what is going to happen with loans that are loans other than the, traditional, we gave you money, you're going to give it back to us on a schedule, or not in this case, again, because the loans are presumably going to be forgiven for some percentage of the borrowers. From Harris on the cheeky comment, what are your thoughts about the Trump administration putting the info online to everyone in order to stick it to the Washington Post? Well, I think that there's always there's always a question on how this administration is going to interact with the press. I think that different agencies have sort of had different levels of antagonism. And I do think that, and one of the advantages of FOIA litigation is that it does tend to cool the temperature down a little bit by putting a lawyer on the other side of the reporter instead of an agency official. At the end, once you file a lawsuit, often it's an assistant U.S. attorney or somebody at DOJ Main Justice who is handling the matter, and not the agency official. And the lawyers who are handling FOIA cases, but also sort of other federal programs things, and who have to stand up in court and explain what the agency's rationale is, are not, they're not inclined to engage in game playing, I would say, sort of in the main. But you never know what an agency is going to do. I don't, looking at the list of plaintiffs, I think there are a number of news organizations that have, that have done important and newsworthy reporting on this administration, and that the administration has, described as fake news. But we will see sort of how that trickles down to sort of the agency level.
So I think this will be the last question here from Karen.
Sure, Karen. Can an applicant who is denied file for the information say if they want to argue there was discrimination? Yeah, so anybody who has, FOIA is available to everybody. You do not have to be a journalist to file a FOIA request. You might have to be, in the business of public reporting in order to get a fee waiver, which for a large enough production can be significant depending on the amount of processing time that goes into it. But yeah, if you are, I happen to know that there's at least one public interest group has filed a similar FOIA lawsuit to get information on PPP loans. It wouldn't surprise me if borrowers, whether successful or denied borrowers, are also have filed or will file their own suits. I know there were initial suits about. Actually, that's true. I do know originally there were some denials of businesses that were for whatever reason. I think there was a lawsuit by possibly a payday lender that was that required litigation to bear out whether they could get PPP money, and so and I know that there has been a lot of consternation about whether Planned Parenthood was able to borrow money. My understanding is they were able to borrow money, but that there was a lot of pressure on the SBA to sort of force the cancellation of the loans. I don't know how that has resolved, but there has certainly been some amount of conversation about who has been denied, if anybody has been denied, and a person who has, whether they've been denied or not, they have rights under FOIA to seek this information. I will say though that as a general note, if you are for a business that has been denied a loan that might be contemplating litigation against the government over that denial, filing a FOIA request may or may not be a good thing, because there's sort of a general rule that you're not supposed to use FOIA as a tool of civil litigation. Like if you're litigating against the government and you have discovery requests, you serve discovery requests, and using FOIA as a discovery tool would sort of fill up the bandwidth that should be used for public reporting and public requests. So I don't know necessarily, I don't know necessarily whether any individual requester who thinks they've been discriminated against would make the strategic draw to file that lawsuit.